Or Simon Bridges.
Mr. Speaker, it's been good to listen to the speeches in this House on this bill. I particularly enjoyed listening to my friend Kennedy Graham of the Green Party, who's given us a learned exposition of dissertation of many theories of law, and in particular treated us to a view on John Rawls and his theory of justice, one of the 20th century's greatest jurisprudence and political philosophers. But given that Kennedy Graham will be voting against this bill, I wonder if he nonetheless is under, I suppose, what we would call a Rawlsian veil of ignorance. But be that as it may, it's good to speak on this bill, because this bill is the result, really, I think, of a consensus around criminal procedure from the Law Commission, from the Justice Department, from various other bodies, that the status quo could not stand, and that there has been for some time, and it's been getting worse, excessive delays, costs and complexities within our justice system, and particularly our jury trial system, that need to be remedied. And one point I want to make just at the outset is no particular change this bill makes, although not all the changes are equal, some are much more significant than others, no one particular makes the difference, but really it is the total package viewed, I suppose, holistically, that makes the difference, and that will, I'm confident, make great improvements to the delays, the costs and the complexities that courts currently labour under, and certainly that victims and accused of crime labour under. I talked in the second reading about the jury threshold and the issues there, and about this, I think wrongly called, but so-called attack on the right to silence that is not in this bill. I want to just today, that's what I said, that's why I said it's not in this bill, Mr. Pascown. But I want to just today talk about a couple of other provisions which I think are pretty significant ones. Sentence indication hearings, clauses 58 to 63, and effectively here what we see in the bill that will soon, I hope, be law, is a codification of existing practice, where an accused, a defendant, can come to court and can ask for a, if you like, mock sentencing to see where he or she would be if they pleaded guilty. Some have been squeamish about this in the legal profession, because in a sense it's, I suppose, having your cake and eating it too. It's saying, you know, to the outside world, look, I'm innocent of this, I'm not guilty, but on the inside, because the fact of the sentence indication hearing suppressed, saying, look, but I'd like to just see because I'm not that confident. But nevertheless, pragmatically speaking, economically speaking, and in terms of saving time, I think this is a very good set of provisions that we've got here. Judges under Clause 58 will be able to say the type of sentence, so it may be home detention or imprisonment. They can go further than was the existing practice by saying, look, we also think it's 2 to 2.5 years, by giving the length and so on. Only a defendant can request the sentence indication hearing, which of course makes sense because it's for his or her benefit. And I think another important provision is the fact that, look, a court will need to have before it a minimum of information, the summary of facts, previous convictions, victim impact statement. As has been the previous practice, there won't be necessarily probation service reports, psychological, psychiatric reports, and that may mean that the sentence indicated at the hearing may change with the real sentencing somewhat, because on certain occasions those reports can make a difference. But nevertheless, look, that's a very worthy part of this bill, just a small part, but again gives a flavour of what this bill is doing. The other aspect I just wanted to highlight very briefly is the trial call-over memorandum that is now to be handed in by both prosecuting and defence counsel in this bill. That again is a codification of a practice that was happening and has been happening around much of the country, but that will also save a lot of time, because what it does is it makes it from the get-go clear to both sides what their positions are, what witnesses they're calling, what pre-trial applications they'll be making and the like. And so, as I say, that brings a lot of certainty and will reduce the costs, the complexities and the delays that we've seen in the criminal courts. So that just gives a flavour of two small parts of a very hefty bill that Minister Power and the Justice and Select Committee, Justice and Electoral, Select Committee should be rightly proud of.
The Honourable Steve Chadwick.